Lecture 7 brings us to further obligations of parties. Now, when we talk about further obligations of parties, we are basically talking about the vendor and the purchaser. A purchaser has several obligations under a sale and purchase agreement. One such obligation is the obligation to pay the full purchase price within the prescribed time. These can be seen in the two cases, the Ching Yik Development and Star Heights Development case, as well as Chong Kai Tai Ringo and Lee Gi Ki. The vendors, on the other hand, the vendor has to have a title to the land that is sold. Even though he may not have the title to the land when he enters into the transaction, it does not matter. What happens is that he must have the title to the land at the time of the transfer, because he has to hand over the title upon completion of the contract without encumbrances. The second obligation of a vendor is to surrender vacant possession. He should be willing to surrender vacant possession of the said property as soon as the purchaser has paid the full purchase price. Once this happens, it indicates that the contract between them is completed. A vendor, too, has an obligation to notify any latent defects that are obvious on the title of the property or the land that has been sold. This is because he will know what are the defects, whereas the purchaser will not know. So, next topic then brings us to breach of contract. How can there be a breach of contract in sale and purchase transactions and remedies? One of the fundamental breaches in a sale and purchase agreement is time is of the essence. This particular clause has to be fulfilled, otherwise it can constitute a fundamental breach. A sale and purchase contract of property may be terminated by any party if there is a breach of the terms, and generally, for each obligation in a property sale and purchase contract, time is of the essence. Termination of contract can be found in Section 40 of the Contracts Act 1950 and Section 34 of the Specific Relief Act 1950. These are the statutory provisions governing termination of contract. When we say fundamental breach, what do we mean? There are some terms in any contract, sale of land or even commodity or any other sale of anything, can be perishable goods, non-perishable goods, but terms that are fundamental importance will cause the contract to be breached and it may be terminated. There are other terms, of course, that are less or of minor importance. We shall now see in the case of Ching Yik Developments in Durian Berhad and Star Park Heights, which was mentioned earlier. Where the term that has been flouted is fundamental to the contract, the innocent party is entitled to treat himself as being discharged from further obligations under it. But where the obligation that has been breached is only subsidiary or minor in nature, the innocent party may not treat himself as being free of his obligations under the contract, although he has an option. He can elect to sue and recover damages for the non-performance of the subsidiary term. What if it's not a fundamental but a minor breach? And Ching Yik has this to say: a party who terminates a contract or treats it as having come to an end in reliance upon the breach of a non-fundamental term will then be in breach himself. He is then guilty of a breach of contract. So what we need to understand is basically fundamental term. The innocent party is entitled to terminate the contract. But if it is a non-fundamental term, he has to exercise some form of tolerance and not to terminate the contract. So these are the cases on breach, which you will have to look at and understand each of them as we go along.